The designated hour having arrived, I call to order this regular meeting of Ansel Glink's Quorum Forum podcast, the podcast local governments need to do business. In the chair, it's me, Daniel J. Bolin. On the agenda today, we're at the 6th annual APA-CMS bar exam planning law session, our annual law school simulation testing planners and land use professionals on the latest in planning law. But first, let's take the roll. We have a partner at Ansel Glink. His land use and zoning advice has helped municipalities, businesses, and entrepreneurs accomplish their economic development goals. He's got a drink, and we're going to ask him about it. Greg Jones is here.
Hi, Dan.
Greg, it wouldn't be a law school simulation without a stiff beverage. What's in your glass this evening?
I'm actually having a glass of water, which is undeniably lame. But I heard some news today that made me think that I had suffered some sort of episode, namely that Scooby-Doo, the children's television show, will be featuring Axl Rose in an upcoming episode. So I couldn't think of anything more confusing or potentially glorious than that. So I decided to stick with water for today because I couldn't possibly top that.
Wow, that is that's sobering news for some and exciting news for others. Though Scooby-Doo has through the years many historic celebrity guests. The Harlem Globetrotters, among others. They would have gotten away with it too if it wasn't for those kids. But thank you for joining us today, Greg.
Happy to be here.
We have another attorney from Ansel Glink. She's experienced representing local governments in the Netherlands and the United States. She has a drink, and we're going to ask her about it. Joyce Jazeer is here.
Hi, Dan.
Joyce, what's in your glass?
I thought it would be a good idea, but I'm having second thoughts now. It's a margarita from a can.
Second thoughts for what reason? Is it?
It's It's a little strong, and it's I don't know. I'm glad that I also have a bottle of water, so that's.
No, that's responsible. Look at these responsible bar examiners that are hydrating. That's good advice. Thank you for joining us. And
thank you for having me.
Today we have a very special guest. She's an assistant commissioner for the City of Chicago's Department of Planning and Development. She's the APA Illinois chapter president-elect, and Nina Amudia is here. Nina, what's in your glass?
Yes, same water, nature's wine. Nature's wine. You know, some of us are civil service employees and can't drink on the job. So,
Mm-hmm.
so here's my water.
That's very responsible. Look at this group. That's fine. Maybe as it gets past 5 p.m., we'll which is very soon. The range of options will open for our panelists. But dear listeners, don't feel free to make this virtual happy hour as happy as you want it to be. Thank you for joining us in the chat. It's Ansel Glink, law clerk, Rain Montero. Please share your questions today, live audience, to Rain in the chat. And thank him for drafting today's trivia questions for us. Thank you, Rain. And behind the glass for our protection, it's Engineer Matt. And we have a quorum. Folks, we are joined here today by a live audience from APA-CMS of bar examinees here on Microsoft Teams. We're going to send our test takers to breakout rooms where you will meet your teammates and choose a captain. Captains should, on your device, visit the website pollev.com/AnselGlink111 That's there to emphasize that Ansel Glink is number one. So 3 times at pollev.com/AnselGlink111 on your device and enter your team's name as your screen name. And after you do that, we'll bring you back from the breakout rooms and get started with the trivia. While you're in the breakout rooms, we are celebrating today the 50th episode of Ansel Glink's Quorum Forum podcast. We'll be talking about asking our panelists for their top 50 Quorum Forum podcast moments. We'll get to that. But Engineer Matt, why don't you send everyone to their breakout rooms for 3 minutes to get to know each other, their teammates, and select their team name. And meanwhile, I'll chat with our panelists while while everyone gets their team set up. Engineer Matt, can you do that for us?
Sure thing.
That might be Matt's first appearance on the podcast. Thank you, Matt. While you're away, while people are doing that, they are getting set up. Nina, it was so crazy. Last year's bar exam, I will never forget it. It was at the Haymarket Pub and Brewery. So it was so much fun that soon thereafter, they had to shut down all the bars in the entire state.
Mm-hmm.
You've
that may have been the last time. I have to really think about it. That may have been one of the last bars I had ever been to before Corona hit.
Yeah, it was for me too. I'll never forget it. But you've accomplished a lot, and during the pandemic, you got the new position with the city, the new position with APA. Before we get to your top 50 Quorum Forum podcast moments, what are you working on at the city and with APA?
Yeah, so with the city, I am an assistant commissioner with the commissioner's office. So I am Commissioner Cox's chief of staff. I help with goals and priorities for the department. I work across all the bureaus to make sure that we're getting work done. Our biggest initiatives right now are Invest Southwest and the We Will comprehensive plan, which is really exciting. So yeah, it's a really exciting time to be working for the city of Chicago. I'm very, very honored to be doing this work. It's what I've always wanted to do. So to do it in Chicago is lovely. Coming from LA and now in Chicago, it's great. And then with APA Illinois, yeah, President-elect, I'll be the first Black president that our chapter will ever have. Has ever had in its history, which is really exciting, but also another realization that, we think we've come a long way, but we have so much further to go. We actually got 5 women of color elected in this last cycle. We did a lot of behind the scenes, getting people riled up, getting them to run, getting more people of color to participate in APA is something that it has been a personal goal of mine my entire career. And so it's really exciting to see our board have more diversity of thought and to have our core members, step up to the plate to really just excel the work that our chapter has already done thus far. So that's really exciting. So yeah, that's just a little bit of what I'm doing.
That's plenty, and I think it's safe to say that none of it couldn't have happened without your appearance on this very podcast last year. There's a correlation, causation. You appear on this podcast, all this great stuff happens. Just think about it, listeners. What could happen to your life just by listening to this podcast? Tell your friends. Great things could happen to you too. Matt, was that noise I heard people coming back from the breakout rooms, or we? It
was not. We have about 30 seconds left.
Oh, 30 seconds. What? Well, in that case, allow me to we'll talk about what's in my glass real quick. I'm drinking this beer from Haymarket Pub and Brewery, the Harold's Honey Ale. We have this event every year at Haymarket. I ordered some Haymarket beer for delivery, and the CEO of Haymarket Brewery came to my door and delivered this beer and said he misses all of us at APA-CMS, hopes that we'll join them again next year. That's that I thought that was pretty cool. But they check it out. This is a delicious beer. It's got a local government angle. It's named after Mayor Harold Washington. So it's delicious. In any event, and I also have water for like the rest of our panelists that are responsible. Matt, is everyone back?
Oh, yes, they are.
Wonderful. Welcome back, everyone. I hope you have your team names locked in. There's going to be 3 rounds of trivia tonight with a possible lightning round. We'll see how it goes. Before each round, we're going to drop questions in the chat for you to download. You're going to take those to your breakout room and discuss the questions with your teammates and come up with your answers. Then you'll come back out of the breakout room. We're going to go through the questions, and your captain is going to enter your team's answer. If we have time, there's going to be a final lightning round, no breakout rooms, no teammates, just your captain answering quick questions for the ultimate prize. Of course, this is a regular meeting, and we do have to have public comment. So to our live audience, please share your questions with us in the chat. Is everybody ready? Okay. Examinees, you have, Engineer Matt, why don't you drop those questions in the chat? This is.
So I need to do that, Rain?
I just sent them, I think. So let's see if this works. They should be in the chat now. And if not, we'll ask Engineer Matt to send them over.
This is exactly how it went in tech rehearsal.
Okay, Matt, if you want to try to send it through, people are...
They should be on there now.
Okay.
But make sure you leave this in the podcast. This is good content. Oh, here we go. Boom. All right, everyone, check out these round 1 questions. You should see them in the chat. If there's any, by the way, if there's any like technical glitches along the way that are in any way like frustrating or stressful to you as a bar exam participant, that's just part of the law school simulation. We're trying to make this realistic and just like as frustrating and stressful as law school might be. People are having trouble at opening those. Let's see here.
Matt, are you able to send those through in a format they're able to open them?
Yeah, I believe I did already.
Hey, Greg.
Hi, Dan.
While people are working on those, what are you guys? What have you been up to in the pandemic times?
Oh, running a school daycare office out of the same building. It's been great.
That's exciting. Rain, if you can email the questions to these folks. I think you're getting some electronic mails. That should work. Greg, what is the most alarming conflict that you've experienced running a daycare and a home office at the same time? Any like I'm a lawyer cat video snafus or exciting things like that?
No, although I'm waiting for the feed to drop at any moment and me to be kicked out of the meeting because of the Octonauts or whatever programming is being streamed downstairs while we talk. So there's that. This week, the most challenging thing I think was was avoiding the falling ice for all the various people that are occupying the house. There's quite a bit of activity from up on the roof the last couple of days.
Yeah, the participants and listeners might not believe that we did have a tech rehearsal for this call, but the thing that we did experience during the tech rehearsal was that a lot of slamming ice out during the call as it's melting away. Oh well, welcome change in the weather. So, Rainey, have you fired off those questions to our friends quite yet?
I am sending the email right now. I just got everyone's emails up on there, so I am sending it now.
Wonderful. In that case, Matthew, why don't you start sending folks to their breakout rooms for their 3 minutes to review these questions, and we will and we will welcome everyone back after you've had a chance to look them over, and then we will answer the questions. And while they're away. Matt, are you able to start sending folks to breakout rooms?
Yeah, sure thing, Dan.
Baller. That is very cool. While they're away, Greg, why don't you share us your top 50 Quorum Forum podcast moments?
Oh man, where to begin, Dan? There's just so many to choose from. I think this ranks up towards the top right now. I'm enjoying all of the downtime as we try and muddle our way through this.
I think it's going very well. People might think that it's like a technology thing, but like we've had similar snafus at in-person events. So
this is why it's better when everyone's drinking, and less good when we're all drinking water.
Right. But another plug for this beer. It's really helping me through this. But hey, Rain, you got that email fired off?
Yeah, I sent it. So
I think, well, Rain, let's get your take. You are a law student, and today is, and the day we're recording this, is the day of the real bar exam, the February Illinois bar. I don't know if you have any friends that are out there taking the bar exam. How is their experience similar to the bar exam we're experiencing here today?
Well, I do have a lot of friends taking it right now, so my heart goes out to all of them. I am glad that I am not taking it yet. I still have some time until then, but I would say that this is very similar to the same difficulties that they're experiencing. The bar exam is online this year, and being administered remotely. And I know that the last session was delayed and also administered remotely. So, can guess there's a lot of problems going on with that.
So what you're saying is that this is a very authentic bar exam simulation that our participants are experiencing here today.
I'd say this is about as close as it gets.
That's very flattering. I deeply appreciate that. Do you think that your participation in this simulation is going to help you prepare for the bar exam?
I sure hope so.
I hope so too. I think this is going to be a valuable part of your bar prep, and really hope you become a lawyer. Hey Matthew, how much time you got left in those breakout rooms?
34 seconds, give or take.
Wonderful. This is very exciting. Looking forward to having everyone back, and we're gonna get back to more conversation about our top 50 Quorum Forum podcast moments. Greg, you've got at least 49 more. But I'm gonna queue up the bar exam questions. Our participants are trickling back in the room. And this is here they go. Here they go. Welcome back, everyone. APA-CMS Bar Exam 2021, the sixth annual. I think the best, personally. It gets better every year. Not that I wouldn't enjoy experiencing an in-person bar exam experience again soon. But this is good to experience with all of you on this World Wide Web. Matthew, is everyone back? I'll take that as a yes.
Yes, Dan. It looks like they are. Sorry. It was on mute.
Wonderful. Here we go. Without further ado, it's round one. We're getting comments in the chat that was not enough time to go through the questions in the breakout rooms. I understand, but the bar exam is very hard, and so here we go. Round one, question one. Here we go. The village board decides to have its board meeting over Zoom. The village board mutes the audio of the meeting for 30 seconds during a sidebar discussion. John challenges the meeting as illegal. What result? Is it John loses because the muting was to prevent the public from hearing filthy cuss words? John wins, but only if the public was allowed to attend the meeting in person? Or John wins because the public is entitled to hear all discussion during a Zoom village board meeting? What result? John loses because the muting was to prevent the public from hearing filthy cuss words. John wins, but only if the public was allowed to attend the meeting in person. Or John wins because the public is entitled to hear all discussion during a Zoom village board meeting. What is the correct answer? It's John wins because the public is entitled to hear all discussion during a Zoom village board meeting. And for more on this, we go to Greg Jones.
Thank you, Dan. And just as a point of clarification, when we wrote this question, I don't think we realized how timely the first answer would be, referencing filthy cuss words. There was a city council meeting today where exactly that just happened without the muting. So kudos to us, I guess. But this hypothetical stems from the legislature amending the Open Meetings Act last summer to add a new remote meeting procedure that authorizes public bodies to meet electronically, subject to following some specific procedures. Many municipalities and other public bodies across the state, as all of you know, have been doing this for months and months and months as a necessity to get through the pandemic. Using different platforms like Teams, probably more effectively than we're using Teams right now, or Zoom, or other electronic means. But last fall, a village board held a board meeting that was using Zoom. And a member of the public in attendance at that meeting filed a request for review with the Public Access Counselor's Office in the Attorney General's office, claiming that the board had violated the Open Meetings Act when it muted a portion of the meeting for a sidebar discussion between the village president and the village clerk that lasted for, it wasn't real long, it was about a minute. The requester also claimed that the village board was in violation of the Open Meetings Act because it didn't allow members of the public to physically attend the meeting, which was being held at Village Hall. The PAC reviewed the appeal and found that the village board did in fact violate the Open Meetings Act by muting the sidebar discussion between the village president and village clerk, despite the fact that it was only 60 seconds long. The PAC acknowledged that there is nothing that would have prohibited a sidebar discussion from occurring at an in-person meeting, so not a remote meeting. But the PAC noted that the new remote meeting procedures in the Open Meetings Act expressly require a public body to ensure that any interested member of the public can contemporaneously, and that's the key word here, hear all discussion, testimony, and roll call votes. And that includes, so says the PAC, sidebar discussions. By muting a portion of the meeting for the sidebar, the public body, the village board in this case, had violated that particular provision of the Open Meetings Act because members of the public could not hear the discussion. The PAC also weighed in on the claim that this was an Open Meetings Act violation because there was no physical attendance. The PAC said that that was not an Open Meetings Act violation because the board had live streamed its meeting via Zoom, which was accessible to the public. The PAC found that this was an alternate arrangement that satisfied the Open Meetings Act because the governor had issued and reissued a disaster proclamation that was in effect during the meeting. And the mayor had also made the appropriate determination that in-person attendance at the meeting was neither practical nor prudent in light of the ongoing pandemic.
Thank you, Greg. That's an important case and important lessons for people that we are still having remote meetings in Illinois, and that this who knows what changes might come to the Open Meetings Act post pandemic. But these are the rules now, and you got to follow them for your local government meetings to comply with the Open Meetings Act. Let's move on to question 2, round 1, question 2. Oh, the leaderboard. First place is FOIA. Tied with LWD +2 and Rain. Fourth place is Dan Bolin. I get it. Anyways, round 1, question 2. Lily has a large home with a large gravel driveway and barn. She allows people to pay to park on her driveway and in her barn. The neighbor sues on the basis that this is not a valid use of residential property. What result? Lily wins if the parking is only used by tenants paying rent to live in her home. Lily wins because a neighbor is not affected by Lily's use of her property. Or Lily loses because parking constitutes a public nuisance. What result? Lily wins if parking is only used by tenants paying rent to live in her home. Lily wins because neighbor is not affected by Lily's use of her property. Or Lily loses because the parking constitutes a public nuisance. Looks like we have a bunch of answers in. Let's take a look at the right answer. It's Lily loses because the parking constitutes a public nuisance. And for more on this, we're going to hear from Joyce. Joyce, tell us about this case.
Yes, I will, Dan. Thanks. This was a difficult question because it's not an easy guess. It is about public nuisance. Public nuisance is an act, condition, or thing that is illegal because it interferes with the right of the public in general. So let's see what constitutes a public nuisance in this case. This case took place in Naperville. We're blaming Lily in the question, but it was actually a Mr. and Mrs. Gaca. And their neighbor, Mr. Frederick, he filed a lawsuit against them, alleging a variety of claims regarding the use of residential property next door to his home. In this lawsuit, Frederick alleged the home's 6 bedrooms were rented out to various individuals and operated as a boarding house. He also claimed there were approximately 20 vehicles parked or stored on the property at any one time, including cars, pickup trucks, delivery. So they had 20 vehicles parked or stored on the property, and some were tenant vehicles, but others were parked there under a separate arrangement or agreement, and that included the payment of parking and storage fees. Ms. Frederick submitted affidavits from former tenants and users of the parking and storage facility, and those demonstrated the illegal uses. This lawsuit was actually based on the Adjoining Landowner Act, and that contains a provision that says to prevent any illegal act, conduct, business, or use in or about the premises. So that would be the public nuisance. Mr. Frederick claimed that these illegal uses constituted a public nuisance and violated various provisions of the City of Naperville zoning ordinance. Well, the trial court ruled in favor of Mr. Frederick. They entered a permanent injunction stopping Mr. and Mrs. Gaca from operating a boarding house and a parking or storage facility on the residential property. Well, Mr. and Mrs. Gaca weren't happy about it, so they appealed, and the appellate court upheld the injunction. They found that evidence clearly established that the property was being used in violation of numerous provisions of the Naperville zoning ordinance, and Mr. and Mrs. Gaca, they still held that the parking and storage facility was a lawful home occupation. The appellate court wasn't having it. They concluded that Frederick met his burden under the Adjoining Landowner Act to establish the unlawful use of the neighboring property, and the trial court's injunction was upheld.
Interesting case. We'll be sure to include a link to it in the show notes. Tricky question for our audience, or our live audience. Let's look at the scoreboard. FOIA in first place, LWD +2, and tied with them, along with Rain, followed by Chicagoland Burnham Buddies in fourth place. We're really coming along here. Round one, question three. Matt and Rain, we're at question three in round one. Feel free to share the questions for round two with our participants while we take on this question. Bob's home is subject to an annexation agreement which states that Bob will not be prohibited from renting out his property. The city passes an ordinance prohibiting short-term rentals unless the owner obtains a license. Is Bob required to get a license? Yes, because the ordinance is generally applicable in a legitimate exercise of the city's police powers. Yes, but only if the agreement provided that city retained the right to enact zoning changes, or no, because Bob has the right to rent out his property under the annexation agreement. Is Bob required to get a license? What do you think? Get your answers in. And here we go. Yes, because the ordinance is generally applicable in a legitimate exercise of the city's police powers. This is the case where a federal court recently denied a vacation property owner's due process challenges to an ordinance regulating short-term rentals. This is Stone River Lodge versus the Village of North Utica. In 2004, Grand Bear Lodge purchased land near North Utica to develop a hotel, and North Utica annexed the land. The annexation agreements between the village and the hotel granted special use approvals for the development of a hotel and a number of buildings that each would include multiple vacation villas. The annexation agreement provided, among other things, that no owner would be prohibited from renting his or her unit, and that right would run with the land and would inure to subsequent owners. The villa owners alleged that they had, for years, been allowed to rent out their units without any regulation or mandates from the village. In February 2020, however, the village adopted an ordinance making it unlawful for anyone in the village to operate a vacation rental unit without a current valid license from the village. As defined in the ordinance, a vacation rental unit is a dwelling unit or portion of a unit offered for rent for a period of less than 30 days, not including hotels, motels, and the like. The ordinance also established standards and procedures for the application and issuance of licenses. The villa owners filed a lawsuit in federal court alleging due process and equal protection claims. In the lawsuit, the villa owners claimed they had applied for licenses but were denied by the village in a letter that informed the owners that only one hotel license is issued to the entire Grand Bear Lodge PUD, and that the villa owners needed to go to the lodge to rent from their rental pool from their license. The court found no violation of the villa owners' due process rights because the annexation agreement specifically provided that the village retained the right to enact zoning changes. The court noted that the ordinance qualified as a zoning change within the meaning of the annexation agreement, and the court also found that the ordinance was a valid exercise of the village's police powers. However, the court did allow the villa owners equal protection claims to move forward against the village. The court noted that the villa owners may have been treated differently than other short-term rental owners because they had to go to this rental pool with the Grand Bear Lodge. As a result, the court allowed those claims to go forward. And for more of this case, I want to turn to our friend Nina Idemudia. Nina, what did you find interesting about this case?
It all, surprisingly, I won't say nothing was interesting about it, but it sounds bad. But to me, I think the answer, at least the correct answer, seems very straightforward with what I've seen out in Los Angeles. These types of ordinances have been popping up over the, Airbnbs over the last, 5 years. And I think I've seen different iterations of this in a lot of different cities that I've either worked in or worked around. So to me, this answer, unfortunately, seemed very straightforward and not exciting at all. Which sounds terrible.
What features of a short-term rental ordinance, what features have you found that are interesting or helpful or useful? I know every community is different, but you've worked in a few, and in a few communities that are tourist destinations, right, and might have more short-term rental activity than others. What are some features of a short-term rental ordinance that you find are interesting?
Yeah, we always have this debate. When I worked for the city of Los Angeles, actually Santa Monica, which is a neighboring city, had almost completely banned short-term rentals. They were very restrictive because obviously they're residents, and also when you think about equity concerns, diversity concerns, they were just not into having those short-term rentals. And, it was kind of like the typical, we don't want people coming in and out of our neighborhoods. We want to be able to regulate it. Where Los Angeles, I think, took a looser approach at first and then kind of came around to having some more concrete rules. I think it is what I see when you look at New Orleans or you look at certain parts of Los Angeles, like South Los Angeles or East Los Angeles, it can be a real savior for some people who are going through economic hardship, and their property or their housing is one way to generate income, especially now that we're looking at a big economic downturn due to the pandemic. But I mean, having people in your home is probably not that safe right now. That's probably not the way to go. But, I have heard arguments from a lot of community groups that these types of ordinances, if they're too restrictive, can potentially, leave out a lot of kind of like the gig economy income for them that helps them to survive and live in their neighborhoods, especially as they become more gentrified and displacement is more prominent. So those are probably the most interesting arguments that I've heard against being super restrictive with these kind of temporary housing. So, yeah.
And to your point about whether it's safe to have other people in your home, that was my first reaction. When the pandemic first hit, but over time, I've been reading about this topic and hearing that actually short-term rentals are expected to be one of the first places to come back as people are traveling shorter distances, or they don't want to be in a hotel with however many other guests.
Or they're moving outside of the city center. I think we're seeing this in Chicago, even pre-pandemic. People are moving out of the city center and then using their condos or their apartments as short-term rentals, which also can affect the affordable housing market because if you have a lot cheaper kind of short-term rentals, it takes those permanent units on a yearly basis out of the market and makes prices go up. So it's really, I feel like it's always a gray area, and we're always like, what we have to balance, but it is truly a balance of being intentional about the ordinance that you're writing, but also not being so restrictive that, people can't benefit off of the extra income.
Fair points all. We could get into the weeds with short-term rentals for the rest of the night, but we do have to move on to round two. Participants, you should have the round two questions from the chat or your electronic mails Leaderboard LWD +2 is in first place, followed by FOIA and Rain. But it's time to move on to round 2. Matt, will you send everyone to their breakout rooms to talk about the round 2 questions? I'll take that as a resounding yes. And
It was a resounding yes.
Well done. And while we're doing that, I do want to talk to Joyce. Joyce, before we want to ask you about your top 50 Quorum Forum podcast moments, but I think one thing that our listeners want to hear about is you've represented local governments in the United States. You've represented local governments in the Netherlands. What are some of the big differences or similarities that you've seen with your experience working in local governments all over the world?
Yes, all over the world. It is actually quite similar. What I saw a lot in the Netherlands was that people are very vocal. So if changes are announced for zoning or planning or economic development, people, they don't want it in their backyard, so they're very vocal. And I represented a couple of municipalities where a lot of people also were lawyers and judges. So they were usually the ones that sort of set up these groups, getting people together to object any changes, and so that was quite challenging. But also because I was also a mediator, it was a good way to practice my mediation skills. So that helped as well. And that's what I noticed, is that people just want to be heard, and people find it really upsetting if a government announces changes as if it's already a done deal. So it's always good to get everyone in and talk about it and explain everything and have everyone's view on the matter, and just get everyone in the room. That's so, and I think over here it's pretty much the same.
Civic engagement, a universal concept. Have you heard about back in the Netherlands whether the same remote meeting, remote attendance concepts have been applied that we're experiencing here in the U.S.?
Yes, it's exactly the same. So, and you see it. I mean, I recently shared on our internal email this video of a parish council meeting in the UK, and those things happen in the Netherlands as well. So it's all over the world, really.
There's some the additional avenues for civic engagement have led for some interesting videos and of meetings online. That is for sure. But do they even have a local government podcast in the Netherlands that is even as close to as good as Ansel Glink's Quorum Forum podcast?
I cannot imagine that to be the case.
That's wonderful, Matt. Glad to hear it. I knew we were one of the best in the world. I'm glad that you were here to confirm that for us. We
You're
are
welcome.
welcoming back participants from the chat, from the breakout rooms. We're moving on to round 2. Let's get to it. It looks like everybody's back. So let's just, without further ado, round 2, question 1. City Council wants to hold a Zoom meeting about a controversial annexation proposal. The meeting will be shown on the city's website, and public comment will be limited to phone and email. Can the city do this? No, because the city must provide a reasonable accommodation to allow parties to attend the meeting. No, because people without phones and internet access cannot participate in the meeting. Or yes, because the public had a reasonable opportunity to participate in the meeting and who doesn't own a phone anyway? It looks like we've got our answers in, and so we are going to look at the correct answer. It is yes, because the public had a reasonable opportunity to participate in the meeting, and who doesn't own a phone anyway? For more on this, it's Greg Jones.
Thank you, Dan. This case is Evans versus City of Joliet, and it was actually filed before the Open Meetings Act amendments were signed into law. This was a challenge to one of the governor's executive orders that allowed remote meetings to occur. And when that order was signed, I'm sure a lot of folks in this meeting were aware that there were, objectors groups and citizen activist groups that were kind of up in arms over the concept of having remote meetings and hearkening back to the smoke-filled room, and all of this is going to be behind closed doors, and a lot of things really haven't come to fruition, but were still voiced. So just a quick overview of this case. There were 4 individuals brought a motion for a temporary restraining order and preliminary injunction, asking a judge to issue a temporary restraining order against Joliet to stop it from conducting a meeting on a controversial proposed annexation for a warehouse distribution and manufacturing facility called North Point. The plaintiffs made a couple of arguments in their motion to the court. First, they claimed that the meeting was not necessary under the governor's executive order. Remember, when the governor first issued the executive order saying there could be remote meetings, there was language in there suggesting that only necessary business and necessary meetings should proceed. So the plaintiffs in this case seized on that and said, why is an annexation proposal necessary in this case? And the plaintiffs also argued to support that there was no indication that the city would be harmed if the vote on the annexation proposal was postponed until an in-person meeting could be held. They probably didn't realize that in February of 2021, we would still be holding remote meetings in many communities are. The second argument that the plaintiffs raised was that the remote meeting did not comply with the Open Meetings Act requirement that the meeting be reasonably accessible to the public. Specifically, the plaintiffs argued that some residents may not have had access to cable TV or the internet to be able to watch this meeting. And the plaintiffs said that the city had an obligation to go farther in providing technical assistance to residents regarding how to attend the meeting, and they should have provided a phone number to answer questions and to assist residents who were inquiring about how they could participate, and a number of other arguments along the same lines. The court heard the motion the morning of the meeting, I believe, and ruled that afternoon. And they determined that the issue of whether or not a meeting was necessary under the governor's executive order was a determination that was to be made by the city and its elected officials and not by the court. So the court declined the invitation to step in as into the role of super legislator. And second, the court determined that the city had provided a reasonable opportunity to participate in the meeting for members of the public that wished to by announcing the meeting 5 days in advance, permitting the public to comment by telephone and email, streaming the meeting live on the city's website, and they even went so far, the city went so far as to post a recording of the meeting on the city's website after the meeting had occurred. The court noted that a very small segment of the population may not have been able to access the internet or cable TV, but that fact alone did not make the meeting held by the city illegal. So the court found that there was no violation of the Open Meetings Act or Governor Pritzker's executive order authorizing remote meetings towards the front end of the pandemic and denied the plaintiff's request to stop the meeting.
Greg, as you pointed out, the rules are changing all the time. This case was from the early days of the pandemic. We're almost nostalgic for it. But
it was a simpler time.
It was, in some ways it was. But there's since been Open Meetings Act amendments. But I think the case still has relevance. Is that you're going to get some some deference during a public health emergency, but I think your acknowledgement to be mindful of the changing rules is a good one. And if the kinds of remote participation that we're experiencing now are going to continue post-pandemic, the rules are going to have to change a little bit more since the current Open Meetings Act amendments require a public health disaster declaration to use these remote meeting tools that I think are pretty popular in some communities. So and have facilitated new avenues of participation. But a good case to know. But we got to move on to our next question. Look at the leaderboard. LWD +2 is in first place, Chicago, followed by Chicagoland Burnham Buddies, and then everybody else. But round two, question two, the city of Whoville puts up a nativity scene in front of the city hall for Christmas. Grinch, who is an atheist, sues to take it down. Is the use of the nativity scene on government property constitutional? No, because religious symbols cannot be put on government property. Is it yes, but only if the nativity scene is next to other Christmas symbols like Santa and reindeer? Or yes, because nativity scenes do not convey a religious message? What's the answer? It looks like everybody's locked in, so let's check it out. The answer is yes, but only if the nativity scene is next to other Christmas symbols like Santa and reindeer. And for more in this case, we're going to talk to Joyce. Joyce, tell us about it.
Yes, I will. Thank you. This case is, the constitutional question is the First Amendment Establishment Clause. And that prohibits the government from establishing a religion. And historically this meant, for instance, that state-sponsored churches, like we see in the UK with the Church of England. But here in the US, we use the so-called lemon test in these kind of cases, where the government can only assist religion if, 1, the primary purpose of assistance is secular, 2, the assistance neither promotes nor inhibits religion, and 3, there is no excessive entanglement between church and state. This case happened in Jackson County, Indiana. And every holiday season they allow private groups to set up a lighted Christmas display on the front lawn of its historic courthouse. And it typically consists of a nativity scene, Santa Claus in a sleigh, reindeer, carolers, and large candy-striped poles. One of the county residents, Mr. Woodring, he sued the county to take down the nativity scene, arguing that the nativity scene violates the First Amendment Establishment Clause because it conveyed the county's endorsement of a religious message. In response, the county argued that the nativity scene was part of its secular celebration of a public holiday. The district court sided with Mr. Woodring and held that the county may not display the nativity scene in its current arrangement. Well, the county appealed. And the Seventh Circuit reversed the district court and held that the county's use of the nativity scene in its Christmas display did not violate the Establishment Clause of the First Amendment. The nativity scene, Mr. Woodring claimed that the nativity scene was a government endorsement of a religious message, but the court reasoned that the display was linked to a long-standing tradition of using the nativity scene in a broader holiday display to depict the historical origins of Christmas. So the court noted that the county's nativity scene is part of a larger display that contains various other symbols of Christmas, like Santa Claus, the reindeer, the carolers, and 7, not 6, but 7 prominent candy-striped poles. Because the display consisted of both religious and non-religious symbols of Christmas, the court found that the nativity scene was used in a broader context to depict the historical origins of the national holiday. As a result, the court held that the nativity scene on the courthouse lawn did not violate the Establishment Clause of the First Amendment.
A helpful case to stay off the naughty list if you're a local government. at Christmas time for your holiday displays that the context in this case was key. This is a recent case, important one, a helpful one for local governments. We'll include a link to it in the show notes. Let's look at the leaderboard. Rocketing ahead is Chicagoland Burnham Buddies, but LWD plus 2 is right behind them, followed by FOIA. Round 2, question 3, Paradise City issued an on-premises only liquor retailer's license to Slash. State adopts a law preempting home rule and authorizing retailers to make liquor deliveries to consumers. Can the city prohibit Slash's off-premises deliveries? Yes, Paradise City only authorized Slash to make on-premise sales. No, state law allows Slash to make liquor deliveries. Or no, it may limit deliveries to where the grass is green and the girls are pretty. Greg, this sounds like a question that's right up your alley.
It's all coming together, Dan.
I can't wait to see that episode of Scooby-Doo, but while we wait for that, let's look at the answer to this question. It's no, state law allows Slash to make liquor deliveries. And so I don't know if you all heard this, but during the recent lame duck session, a lot of stuff happened. One of the things that happened is a bill passed both houses that the Illinois General Assembly facilitating liquor delivery by retailers. If signed by the governor, Illinois Senate Bill 54 would amend the Liquor Control Act to provide that nothing in the Liquor Control Act will deny, limit, remove, or restrict the ability of a holder of a state retailer's license to deliver alcoholic liquor to the purchaser for use or consumption, with just a few exceptions. Except for Chicago, home rule and non-home rule units alike may not regulate the delivery of alcoholic liquor inconsistent with the proposed statutory amendments. Delivery means the movement of alcoholic liquor purchased from a licensed retailer to a consumer through delivery within the licensed retailer's parking lot, including curbside for pickup by the consumer, delivery by an owner, officer, director, shareholder, or employee of the licensed retailer, or delivery by a third-party contractor, independent contractor, or agent with whom the licensed retailer has contracted to make deliveries of alcoholic liquors. Deliveries must be made within 12 hours from the time the liquor leaves the retailer's licensed premises, and delivery does not include the use of common carriers. While nothing in the Liquor Control Act will limit authorized deliveries, other laws surely will, including the Vehicle Code's open container law. With the governor's signature, on-premise only licensees and other licensed retailers could make the liquor deliveries authorized by the amendments. Of course, many local liquor commissioners are already allowing this under guidance issued by the Liquor Control Commission in response to the pandemic. And additionally, many municipalities allow delivery and carry out of cocktails to go, but based on previous statutory authorization, but that's due to sunset on June 2nd, 2021. Right before my birthday, Greg. Can you believe it? But
it's marked on my calendar and circled, Dan. I would never forget.
So as the legal landscape hasn't settled yet with the liquor delivery here, but I know communities are already reviewing their ordinances to be ready for possible changes. So for more on this, I want to talk to Nina. Nina, the city of Chicago would be exempt from these proposed amendments possibly, but that's because the city of Chicago is special, right?
Yes, I live in Chicago. I live in Archer Heights, which is on the southwest side, and I actually just got some liquor delivered like maybe a week ago. Like I got my skinny margarita mix delivered. They had to scan my ID when they came to my door, and it was actually very easy. Fun fact about me. when I was a baby planner for the city of Los Angeles, that was my first duty in the planning department. I did alcohol entitlements. And so California's alcohol entitlements and statute at the state level and the city level are somewhat similar to Chicago and Illinois. But I will say California is surprisingly more restrictive with their alcohol licenses. And so that was always the game to play when we were allowing people to have on-site or off-site sales in Los Angeles is that, you know, we had to deal with this. We had to deal within the confines of the state statute in certain instances, where I think in Chicago it's a little bit more liberal, I'll say. With you can literally get alcohol anywhere, and the whole BYOB thing was something completely new to me when I moved here. So just a little interesting fun fact about my first little baby planner job was giving strip clubs alcohol licenses. Literally, I used to have to go on site. Yeah.
Well, you understand why it's more liberal here. I mean, there's no winter in LA. We go into hibernation for 4 months. What else are we going to do?
What are you going to do? Yes. And I mean, alcohol delivery, especially, again, going back to the pandemic, if you don't want people congregating at bars and being a little bit more liberal with their mask uses and stuff, having alcohol delivery is probably the better way to go without completely stifling the alcohol industry. So
absolutely.
Yeah, I think this is something they opened up during the pandemic. It's something that a bell that you can't that can't be unrung post the pandemic. I think there's some form of liquor delivery. Well, it's not settled yet how it's going to be in Illinois, but we'll see. Let's see here. Round 3. Let's send those questions over to our participants, and we've got Rain. If you could shoot out those emails, and Matt, drop them in the chat, and we'll get ready to send people for one last trip to the breakout rooms to discuss the final few questions. Meanwhile, we'll look in the chat. We've got a comment in Missouri. The legislature overrode home rule and banned cities from banning plastic bag bans. We call it the plastic bag ban. Seriously, an important point about preemption. This is this liquor delivery law would take away home rule for outside of Chicago, and so that's an important reason why all communities outside Chicago will have to take a look at their liquor delivery ordinances. It looks like the questions are in the chat. Please download them. Rain, I think, is emailing them off to our participants.
Questions are up.
And with that, Matt, please feel free to send everyone off to their breakout rooms to talk about our last official round of questions. Meanwhile, I'll open it up to our panel for final thoughts. But before we move into our last round of questions, any comments about plans you're working on, Nina? Favorite top 50 podcast moments? Let's hear it all. Nina, you first.
Top 50 podcast moments. Let me think. Plans that I'm working on. Well, I do a little bit of everything because I work for the commissioner, which is over the entire city. But,
Sure.
you know, some podcast recommendations I do have.
Like this.
For some really good, if you want to get into some like planning nerd stuff, there's a podcast called The City, and the season 1 was actually about Chicago. It was about Silver Shovel. Yes. Operation Silver Shovel, the Lawndale trash dump. I think that's the name of it. That was very interesting for me to listen to and kind of learn about Chicago history and politics. There's another one. I'm from Detroit. If you're looking at the camera, I have lots of Detroit memorabilia behind me. There's another one about the city of Detroit. Oh, and now I'm blanking on the name. Oh, what is it? Anyway, I'll have to put it in the chat later. And then there's a third one called There Goes the Neighborhood. They have 3 different seasons. The first season was in New York and the second season was in Los Angeles. And I forget what the third season was, but that's also a really good one about gentrification in different cities, how they almost look the same and even in different contexts. So those are probably my top 3 planning podcasts.
That's outstanding. I'm sure coming in at number 4 is the Ansel Links Quorum Forum podcast, but also there's
top 5.
but seriously, check out APA's People Behind the Plans podcast. Nina was interviewed on that podcast, and a nice. It's been a couple years, so you can hear more about her time in Los Angeles and a little bit earlier in her career before she got started doing all these great things in Chicago. Greg, Joyce, top 50 Quorum Forum podcast moments. What you got?
Oh my God. I've only been here for a short while, so I couldn't name them all. But I do enjoy listening to your podcasts. And it's always very informative and fun. So I applaud you for this. Congratulations on your 50th.
Thank you, Greg.
I don't know if this is a top 50 or not, but I enjoyed it. The Guns N' Roses synergy with this today was amazing. I didn't write that Paradise City question or see it before we got on here today. So if that was you, Joyce, or Dan or Nina, I don't know who did it, but thank you. I love a good theme.
I knew you would like that. Rain named the city Paradise City in the initial draft, and I added Slash to the mix.
Outstanding.
If there's anything that Greg likes more than a good local government podcast, it's 80s hair metal. And, and I reckon
in podcast form too. I mean, there's some good ones out there. So Wind of Change, check it out.
Folks are coming back from the breakout rooms. Let's take a look at the leaderboard. Chicagoland Burnham Buddies is the leader after round 2 with the LWD +2 right behind, followed by Winners 111. And that's our top 3. Here we go. Round 3. Let's get into it. Without further ado, and round 3, question 1. One day, Mayor Joe sends an email from his Hotmail account to City Alderman Janet's AOL account about a proposed housing redevelopment project in city, saying, "No way this project goes through, not enough $." What year did this question take place with these Hotmail and AOL accounts? Is the email subject to FOIA? Yes, because Joe is a, quote, public body, end quote, within the meaning of FOIA. No, personal email accounts are not subject to FOIA. Or yes, but only if Joe sent the email during a city council meeting. It looks like all our answers are locked in. Let's take a look. Yes, because Joe is a public body within the meaning of FOIA. For more on this, let's talk to Greg Jones.
Thanks, Dan. So the issue of whether emails and text messages of a public official sent or received on a private device or a personal account are subject to FOIA has been discussed a lot recently. There was a case involving the city of Champaign where the 4th District Appellate Court ruled that some electronic communications on private devices or personal accounts may be releasable depending on the circumstances surrounding the communication. So, for example, if you have a city council member who's sitting at a city council meeting texting another city council member, that communication is subject to FOIA. Since that case was decided, the public access counselor out of the Attorney General's office has issued a number of opinions that have kind of pushed beyond what that 4th District Court said. and have been urging toward more disclosure of communications involving personal devices. This case, which is the Better Government Association versus the City of Chicago Office of the Mayor, is out of the First District Appellate Court. And the First District Appellate Court found that the city had violated FOIA by not turning over text messages and emails of certain city officials that were contained on the city officials' private devices. So a little bit of background, the BGA submitted a FOIA request. We're going to try and use as many acronyms here as possible. To the City of Chicago's Office of the Mayor and Department of Public Health, which is the CDPH, seeking records relating to the discovery of lead in drinking water at Chicago public schools. Admittedly, this issue matters a little bit more when people are actually in the school buildings, but that's a whole nother podcast discussion completely. In response, the city produced some records, but withheld or redacted others, citing various FOIA exemptions. The BGA sued, claiming that the city had violated FOIA by failing to inquire whether city officials had any personal text messages or emails that were responsive to the request. The circuit court had ordered the defendants to search personal text messages and emails of city officials for responsive records, and the city appealed that decision. The appellate court upheld the circuit court's order that the city must search these private devices and accounts, and concluded that communications pertaining to public business within city officials' personal text messages and email accounts are public records under FOIA. And further, that the city had failed to conduct a reasonably diligent search by not asking whether the personal accounts of officials named in the FOIA request contained responsive requests. So the city had an obligation, the court says, to not just search the records that are on city accounts and city servers, but also to ask the individuals identified, the public officials identified in the FOIA request, whether they have any responsive records in their private accounts. The First District acknowledged that officials aren't public bodies in and of themselves under FOIA. However, the court did determine that doesn't mean that their communications about public business can be shielded from FOIA by simply using personal accounts or personal devices to communicate. The First District Court acknowledged the Fourth District Court's decision. This is the Champaign decision we talked about earlier, where they said if you're communicating during a city council meeting and there's a majority of a quorum present, then that constitutes a public record, and determined that in this case, the Fourth District didn't go far enough. The Fourth District concluded that City Council was conducting business only in certain limited circumstances, but the First District did not restrict its ruling to just those circumstances. Instead, the First District held that individual officials could function as a public body, and as a result, their communications could be subject to FOIA in other circumstances beyond a meeting or a quorum, and particularly because the city officials at issue in the Chicago case had the authority to make unilateral decisions that could be binding on the city. So that's new law here that goes far beyond what the Fourth District ruled in the Champaign case. So the First District reasoned that otherwise, or concluded that if the result was that those communications could be shielded, that FOIA's purpose of encouraging transparency and openness and sunlight on government would be defeated. So what does this mean for Illinois local government officials? Well, one, it kind of depends on where your community is located. The Fourth District's decision covers territory down around Champaign. First District is obviously up around Chicago. The First District has taken a broader view on what records must be disclosed as compared to the Fourth District. So we obviously have a conflict here between two districts. Some best practices to help navigate that conflict are to encourage any public official who's talking about public business to communicate only using their city or village account. And realizing that people tend to email folks out of the blue about a variety of different topics. If you get an email on your personal account that relates to public business, it's a great idea to forward that email to your work account so it can be searched during the standard FOIA procedures and likely will reduce the potential that your FOIA officer or village attorney or city attorney will have to dig through your personal account to determine whether or not there are any responsive records. So this is an interesting case. It created some new law. This, like some of the other topics we talked about earlier tonight, is an evolving field. And we expect to see more decisions coming down that kind of define more clearly the parameters of what needs to be disclosed in response to a FOIA request.
Thank you, Greg. This is an important case. We will include the link in the show notes. That's good advice how to respond to it. Make it easier on yourself for that reasonably diligent search. Keep the public records and the public devices or public accounts and forward them messages you receive off of there to those public accounts and devices to just make it easier on yourself to perform that reasonably diligent search. We've had clients who've had their weekends ruined searching through personal accounts looking for whatever emails. Stay organized. Help out your FOIA officer. Look at the leaderboard. LWD +2 edges ahead of Chicagoland Burnham Buddies. They're going to want us to followed by technical difficulties, which I think is the real champion today, no matter what happens.
They're making a late run. Technical difficulties is charging from behind. This is impressive.
Right. Anyways, in any case, round 3, question 2. Park District has an app that allows people to find the nearest park or recreational center. Greg, a blind man, is unable to use the app and sues under the ADA. Is the Park District liable? No, because apps are not required to be accessible to the blind. Yes, but only if Greg shows that he has no other way to locate the nearest park. Or yes, because parks are places of public accommodation. It looks like everyone's answers are in, and we're short on time. So let's look at the answer. The answer is yes, because parks are places of public accommodation. For more on this, it's Joyce.
Yes, thanks, Dan. It's an interesting result from the answers. The key word here is public accommodation, and under the ADA, or the Americans with Disabilities Act, public accommodation means business, including private entities that are open to the public or that provide goods or services to the public. Well, this case, I think we're nearing dinner time, so everyone will probably love this case. It's about Domino's Pizza. In this case, Mr. Robles, he's a blind man. He accesses the internet using screen reading software, which vocalizes visual information on websites. And Mr. Robles tried on at least 2 occasions to order a customized pizza online from a nearby Domino's because the website and app were not designed in a way that his software could read them. So he decided to sue Domino's, seeking damages and injunctive relief based on Domino's failure to design, construct, maintain, and operate its website and app to be fully accessible to and independently usable by blind or visually impaired people in violation of the ADA. Well, Domino's moved for summary judgment. Their grounds were that the ADA did not cover Domino's online offerings, and applying the ADA to the website or the app violated Domino's due process rights. The district court held that Title III of the ADA applied to Domino's website and app, but they found that applying the ADA to its website and app violated its due process rights because the Department of Justice had failed to provide helpful guidance despite its intention to do so in 2010. So the district court granted Domino's motion to dismiss, and of course Robles appealed. On appeal, the Ninth Circuit upheld the district court's finding that Title III of the ADA applies to Domino's website and app. The court reasoned that the inaccessibility of Domino's website and app impedes access to the goods and services of its physical pizza franchise because they say there is a nexus between Domino's website and app and the physical restaurant, and that was sufficient to bring the website and app within the purview of the ADA, because customers use the website and app to locate a nearby Domino's restaurant and order pizza for delivery or pickup. Regarding the due process argument, in rejecting Domino's claims that applying the ADA to its website and app violated its due process rights, the court reasoned that since the ADA's enactment in 1990, restaurants have been put on notice that they must provide full and equal enjoyment of their goods and services to people with disabilities. So Domino's knew that that was their obligation. The court found that even though the Department of Justice failed to issue further guidance, Domino's was not excused of its statutory duties under the ADA, and as a result, the court found that no due process violation occurred. So Mr. Robles won.
Whoop, I'm on mute. Hey, I'm not mute. Hey, so that's an important case. Local governments are being sued over their apps and websites across the country. This case was not a Seventh Circuit case, but it's one that it is having local governments take a look at how they make their meetings or their websites and apps accessible to persons with disabilities. That's why we talk about making reasonable accommodations for remote meetings or any meetings for that matter. And it's an increasingly urgent issue for local governments. These same arguments could be made here in the Seventh Circuit, so it's an issue to be mindful of. But let's move on. It's LWD +2 ahead of Burnham Buddies on the leaderboard. Going into round 3, question 3, city passed an ordinance requiring a permit to solicit money in the streets, and only registered charities are eligible for a permit. Katie is cited for selling lollipops to passing cars to buy a train ticket home. Katie sues, claiming the ordinance is unconstitutional. Will Katie win? Katie wins because the city must have a compelling interest to regulate street safety. Katie loses because the content-neutral ordinance only regulates the flow of traffic. Or Katie wins because the ordinance treats lollipop sellers and registered charitable solicitors differently. Looks like we've got a few more people locking in their answers, and the answer is Katie wins because the ordinance treats lollipop sellers and registered charitable solicitors differently. This is a case in 2019 after two individuals had been cited for soliciting money on village streets. They filed a lawsuit against the village of Downers Grove and various village, state, and county officials to challenge the constitutionality of an ordinance that prohibited their activities. The village had enacted an ordinance based on a state statute in the Vehicle Code. The state statute prohibits persons from standing on a highway for the purpose of soliciting contributions unless the solicitation is within the municipality, is expressly authorized by ordinance, and the solicitor is registered with the Illinois Attorney General as a charitable organization. The village repealed its ordinance, and the parties entered an agreement that in January of this year. That ruling expressly concluded, as a matter of law, that section of the Vehicle Code is a content-based restriction on the freedom of speech and is not justified by any compelling interest, and that that provision violates the First Amendment and is unconstitutional on its face under clearly established law, specifically the Supreme Court decision in Reed v. Gilbert and the Seventh Circuit decision of Norton v. City of Springfield. Based on this ruling, municipalities are reviewing their own solicitation ordinances for necessary amendments and modifications for current practices regarding to enforcement. Doesn't mean you can't prohibit or enforce content-neutral regulations like regulations impeding the flow of traffic, but this ordinance was adopted under the authority in the vehicle code. Many communities adopted ordinances just based on that authority, and so communities are reviewing it, reviewing their ordinances. We'll include a link to the case in the show notes. So let's look at the leaderboard. Round 3 is over. LWD +2 is number 1. We followed by Chicago Burnham Buddies, and followed by technical difficulties. So close. This was a
real nail biter.
A real nail biter. What a competition. The chat is just erupting with erupting with the unsuccessful teams, but here it is to LWD +2. Your prize is being named champion, the APA-CMS Bar Exam 2021, 6th annual. Congratulations. I do want to turn it over to our panelists for final comments. I know we're running short on time. Nina, do you have any upcoming APA events or other events that you want to mention, or thoughts on the cases we discussed today?
Yeah, I mean, there's lots of things going on with APA, with the chapter, lots of cool changes happening. We are having a event that the DEI committee is putting out about the planner's case for defunding the police. I think is going to be a really interesting conversation, and I want to get the date right. So I don't want to tell a lie on air. So let me let me double check the date. So we have that. We have new committees forming in APA Illinois. We have a programs committee. So if you're interested, no matter where you are in the state, if you're interested in helping us interesting programming similar to this one, please reach out to me or to the chapter generally about getting involved. We want to see more people.
Well said, and feel free to send us any events you'd like us to include in the show notes, and we'll be sure to include them. Joyce, Greg, you got any events or speeches or articles coming up?
Yes. Well, first of all, well done to everyone who participated today. I will be speaking in April on the APA-ISS Spring Conference, together with one of the partners of our firm, Shantae Rains. We don't know what we're going to talk about yet, but we're going to find a nice topic, and hopefully it'll be interesting for everyone to listen to. So, and thank you for having me in this podcast today.
Send your suggestions to Joyce, everyone. And
yes,
Greg,
please do.
Greg, what do you got?
Well, let's let these people eat some dinner. I'm going to take a beat and just recover from all the excitement of this wonderful event. Thanks for everyone that participated. It was great to see your names in the chat column. Thanks, APA, for having us. This is always wonderful.
Agreed. Thank you, APA-CMS. Thank you to our live audience. Thank you to APA Illinois President-elect Nina Idemudia, Greg, Joyce, Rain, Matt, everyone in Ansel Link. Thank you for doing this. And before we go, I want to remind everyone to subscribe and leave us a review wherever podcasts are heard. We prefer good reviews. Email us your questions and show ideas at podcast@anselglink.com. And as always, you can visit us online at quorumforum.anselglink.com. Can I get a motion to adjourn?
So moved.
Second, all in favor, the ayes have it. We'll see you next time in Ansel Glink's Quorum Forum podcast. Great job, everybody.